off.
Okay.
All right.
All right. Well, welcome in everyone to our webinar today. We have a couple of really awesome guest speakers for you guys today. And our topic is AI for legal firms. We're going to be talking about the pros and the cons. So let's jump right on in. So first, about Bite-A-Gig. We help small businesses, startups, and entrepreneurs reach their full potential by providing comprehensive and full-scale IT services at a fraction of the cost of a full IT department. And we consist of an elite group of nationwide remote experts with a network of on-site technicians available across the U.S. And our speakers for today, my name is Josie. I work in the marketing department here at Bite-A-Gig, and I'm joined by John Jackson, the founder and CEO. And our guest speakers are Christopher Marston from Exemplar and Martin Medeiros from Buckley Law. A little bit more about our guest speakers. Christopher Marston from Exemplar is the founder and chief executive officer. Christopher has dedicated his career to redefining the professional services landscape. Christopher launched Exemplar Law Partners in 2005, establishing the first law firm in the U.S. to abandon the hourly billing and adopt a value-based pricing model. With degrees in law, finance, and entrepreneurship, and a spirit fired by innovation and challenging outdated business norms, Christopher has led Exemplar with a focus on disrupting traditional business models. Very cool. And we're also lucky to have Martin Medeiros from Buckley Law here as well. He is a business lawyer, author, and speaker with advanced knowledge in corporate, entertainment, copyright, trademark, and startup law practices. And with more than 20 years of experience, Martin helps organizations build value by treating intellectual property as a strategic asset. He is a resource for clients who need to manage internal legal issues such as transactional and disputes, and provides leadership to internal resources and management of external professional services. Martin also works with clients to look at what strategic, tactical, operational, and contingent priorities require resources and which do not. So we're really lucky to have both of you guys here today.
Welcome, gentlemen.
Yeah, that was a big intro.
Thank you. Great to be here.
All right, so I guess I'll take this topic here. So talking about artificial intelligence, and that's, using machine learning capabilities and technologies that simulate human intelligence to perform routine tasks, as well as to intelligently be able to make decisions. And so the context of this webinar today is can this help the legal industry? There's a lot of AI fluff out there going on, but there's also a lot of real possibilities for the legal industry. So when we're talking about doing contract analysis, predictive coding, legal research, and things like that, there's a lot of software companies out there, Thomson Reuters being a big one, as based on my understanding, that have already acquired other AI firms and that are actively pushing AI products into the legal industry. So we want to have kind of an open discussion here with these two experts today, and I'm very, very pleased to know both of them, and glad to have their acquaintance and their expertise here today. So. We're gonna talk about what are the pros with these AI software platforms that are built specifically for the legal industry, as well as the generalist platforms out there. Like, are people using ChatGPT, Gemini, and some of these other platforms for legal type tasks already? Probably, I would guess so. Should they be? That's going to be the topic today. So, without further ado, let's show the next slide here. So I'm going to open up this question first of all to Martin and talk about, Martin, from your perspective, what are the pros of AI when it comes to being used in a legal firm? What is the opportunity here, and how can this help legal firms here today in 2024?
I think the primary benefit is this idea of time efficiency. Lawyers typically sell either their time, whether that's value priced or hourly. And if you're in either one of those, you want to do things efficiently. So the best way to do that is to access some type of artificial intelligence. And I think this is not new to law firms. I remember in 2005 we used AI at K&L Gates for discovery tools, and we did basically that allowed attorneys and paralegals to go through hundreds of thousands, if not millions, of documents looking for relevant facts that support the case. So that's been around, and that time, my first job. I was at Arent Fox in Washington, D.C., and I designed if you remember, I'm going to date myself, Database 3 system that basically was typing in records of a document production that was 60,000 documents, which was huge. It took up an entire file room, and we had data coders put in the relevant data. We had people looking at the documents, and they would star it, hot or medium or disregard. And that was just a searchable text relational database. Fast forward ahead, I hate to tell you, but that was kind of in the 90s. But fast forward to current technology, and it's almost like an order of magnitude how many documents you now can look at for relevancy using what we call issue spines, or we used to in the early aughts. Now it's LLMs, where it's really looking less like kind of the machine learning, more like artificial intelligence, where they can glean, oh yeah, this is relevant, this is going to help my case. So I think that's something that's been around. I think that's a huge positive. Time inspection, reviewing contracts. There's a lot of products out there. I've been tasked at Buckley Law with kind of demoing a lot of these products. They're all over the mark. Some of them I have real security concerns with. They require some adding of widgets and add-ons to, say, Word, which kind of goes beyond. If you have like a VPN, it'll really create a access for bad people to access some data. Also, you have to be careful of where the training data is. You don't want your training data to be seen by your opposition, the person on the other side of the lawsuit. So to that end, there are containerized LLMs where you give it the docs that you want them to train on, and the security concerns are less. So those are very, very positive. E-discovery, document review, drafting a quick demand letter, at least a template of one where you can add in the facts. But with all this time saving, you need a human looking at it. You need an attorney looking at it, because right now, you mentioned Thomson Reuters, and they rank how good their LLM is by year of law school and how many years they've been practicing. The best I've heard of is a first-year law student that graduated in the upper percentile on the bar exam, 90th percentile. I think that it's subjective. It's like they don't disclose their methodology and how they get those, but probably in the next 5 years, you're going to see a lot of improvement on the quality of those types of tools.
Cool. So I know you kind of got into a little bit of the cons and the concerns already, but
sorry.
So from a blue sky perspective here, it sounds like where law firms could start using AI today, if they aren't already, or if they're exploring it. Based on what you're saying, is like there's some definite use cases for research, because that technology has always been there. It's just now kind of morphing into AI. And as we all know, AI is a big buzzword right now, and a lot of AI has been around for a long time, really.
Right.
So we're just starting to, I think what we're starting to see is an acceleration of adoption of people
Yeah.
starting to understand what AI really is and what it can do. So, Mr. Marston, what are your thoughts about the pros and the opportunities with AI for legal firms?
Yeah. Well, we're in a bit of a unique situation. Exemplar's fixed and value-based price. So unlike lawyers who bill time, we make money when we save time. Because whereas a traditional hourly billing lawyer doesn't want to be, they want to be efficient, but not too efficient, because you're too efficient, you bill less, right? So our business model is seeking disruptive ways to get to answers quickly. But I think there's inadvertent use of AI, which is just going to say that any of the subscription tools like LexisNexis and Westlaw, things like that, they're already integrating AI into their services. And that's where I think law firms are likely to begin using it and not even realize it. We're looking at use cases that help analyze and compare statutes in states, and not having to dumpster dive through statutes to find, like minority shareholder rights and in Wyoming versus Delaware, and comparing the two. For instance, I find that helpful. But Exemplar is exploring its own use cases instead of using the big software companies. So feeding a large language model policies and practices around how engagement letters terms for our firm need to be done, or certain standards around compensation, for instance, that as we're scaling, people have questions about how our business model works, and can ask AI and get answers quickly on that. We're using them in creative ways around policies and procedures, things like, what is your reimbursed expense policy? Every firm has it. And, some firms have a policy in a pitch deck. Some of them have it in a PDF. Some have it in a Canva. Some have it in a Word document, and it's some saved over here. Some's on an intranet. And depending on how old you are, you're all going to go to different places. Our guys over 50 all go somewhere else than the guys, the millennials all go somewhere else first. AI can let you figure out whatever form you originally communicated, whatever it is, and it could go find it for your people and give it to them rather than them having to go find it. That's a couple examples.
Cool. Thanks for that. A couple follow-on questions here. When it comes to the pros of AI, I feel like that from my perspective, when it comes to AI, we're going to see a lot of the cons dwindle down. Like the detractions are going to be less and less over time. So question for you, Martin, where do you see AI and the legal industry helping the legal industry in 2 years from now? Like, how is this conversation going to be shifting over the next 2 years?
Yeah, it's a great question. I think there's going to be shakeout because there's a lot of legal AI companies. And you mentioned Thomson Reuters, and a lot of them I demo their products. I'll say, all right, who are your funders? And it's Thomson Reuters. So Thomson Reuters, I think, has put down money in hedging its bets. Not all of those startups are going to make it. Not all of those have the better technology. And some of them that may have the better mousetrap may fail because of execution or something else. So I think we're going to see that vetting right now. And I am seeing it. I'm seeing every day some of these vendors coming out, hey, that old thing we had, it's here's the new thing. Yeah. And it's getting better and better. I don't want to say exponentially because I don't know the math growth and code efficacy, but I do think that you will be seeing the practice of law change pretty significantly in the next 2 years because as not only speed and time, but also quality, I think there's only so much time that someone can devote towards a case, and only so much a client is willing to pay to solve that, because it's risk return. Every client, so the market, the legal market butts up against what can be done. But if you can deliver a really high quality work product in a short time that's very affordable for the client, a lot of good things happen. You get to have more clients on the legal firm side, law firm side, but also more people have access to justice. More people will get the solution that they don't need to pay a $20,000 retainer just to get engage a law firm just to have a simple question answered, because it'll be volume, and we can, it's what's happened in the architecture and general management of firms. You see, it used to be like, very few partners, a lot of associates. Well, that's kind of leveled out. That pyramid, if you will, hasn't. You've seen it be more vertical, almost as many partners as associates. And that's bad for young lawyers because there's less spots for them. How do they train? How do they get information? So my prediction, and I love making predictions because there's absolutely no accountability, is that we're going to see a regrowth of more associates who know, Gen Z, knowing how to use these tools, how to do great prompt engineering so they can provide justice to more people.
Yeah.
Chris?
Yeah. Well,
what are your thoughts about where we're going to be in 24 months?
24 months, huh? Well, we're testing. Yeah, we're testing 2 or 3 use cases, AI use cases in-house now, to pick one that's permanent. And we probably we're going to add that every year, add 1 or 2 different distinctive AI use cases. Like right now, we're exploring a very cool use case involving institutionalizing our knowledge, knowing what we know. And that's, we're growing so fast. So an example of, we knew we add, we're law, business, tax, capital, wealth, insurance. We've got professionals in all these disciplines. And the day we have somebody join us is the day our intellectual capital just went up by X, Y, and Z capabilities. How do we know what we know? How do we know what we are now capable of? And can we use AI or an avatar in AI to be able to speak to the expertise the minute we have it? That's one of our exciting use cases. So with any luck, 10% of us are always the pioneers, right? We're going to try stuff out and begin using them. And I think that at the moment the competitors start eating your dust is when they the lemmings come along and have to sort of follow. And we see that in every industry with every disruptive innovation. So I just think a few will take hold and in the top firms, and we'll use it to our competitive advantages respectively, and off we go.
Yeah, it sounds like you're really, your use case is really focused on not just AI as a legal tool, but also as a knowledge management and organization tool, feeding information across multiple disciplines into one machine that you can then query based off of what you're saying.
Maybe I think about it like this: knowledge firms are companies after all. We're just businesses. It just so happens that the business is knowledge. Exemplar's business across all the knowledge industries: law, business, tax, capital, wealth, insurance. So it's still a knowledge firm. And to that extent, as AI can be useful to disrupt legal and tax and wealth and all that stuff, stock market predictions, all kinds of fun stuff. But the business itself like any business, has a ton of use cases. And so we are exploring those business use cases that aren't just how it helps professionals bill more or be more effective for clients. How does it make the machine itself, which supports the professionals, easier to deal with? And all of that could be like, how do you manage the leads? Your professionals bring in new customers, and lead management is still, they got to go log into a CRM. You ever managed to try and, how hard it is to get a lawyer to log into anything, let alone interact with a CRM system? Only Martin understands this, right? Forget about it. And if you're over 50, forget about it. But it's
No, it has been tried many times with attorneys, and it has failed.
Yeah, that's about it.
I mean, even getting regular salespeople, business development professionals, where that's their discipline, to use a CRM is often difficult for many organizations. So I can't imagine how much harder it would be if that's not your discipline.
Yeah. So, if AI could be the seeing eye dog, instead of hiring 5 admins to help people enter information that would ultimately take them 1/8 of the time to do it themselves, but they won't. then God bless AI.
I think that's the quote of the day: AI being the seeing eye dog.
Yeah.
Yeah.
I mean, because there is a lot of information, there is a lot of inputs in our life and a lot of distractions. And if you never had, ADD, you do now with new technology.
Yeah.
And sifting through that and focusing on what's relevant is really important. I went to a conference it was actually by a Munich startup, and they do AI that helps people negotiate transactions. And they did testing and whether or not the professional negotiators were better. And it depends. So if it's a process-based type negotiation, we're talking about commodity buys. We're talking about auction type transactions. AI outperforms humans already.
Yeah.
If it's more of the more complexity, more rules based, they claim their engine is as good as someone who's been negotiating in that space for 20 years. So it's a big claim, but you can see that the more complex the output, the desired output, the more AI is getting into that space.
Yeah. I have just a thought to hop in if I could.
Sure. Yeah.
In the last several minutes here, I think the biggest things are going to be, like I said, inadvertent use through LexisNexis, Westlaw. That's going to happen anyway. So I think that's probably part of the good stuff. I think the winning in the future as a knowledge firm is going to have proprietary models that sort of do unique stuff for your business and give you an advantage. But you're going to have somebody that's dealing with data training, large language models in the organization. So there's one new job that probably replaces 3 or 4, at least. And we're going to have to deal with the fact that this market is changing so fast that you could be training a model and a better one will come out in 6 months, and you have to retrain a new model. And that's just how it goes.
I want to ask you, what are your concerns about AI and feeding information such as, like you were talking about, proprietary information, confidential information that maybe you don't even want other members of your firm to necessarily be privy to? So let's start there. What are the privacy concerns that you have about using AI in your firm?
I think the privacy concerns are related to, permissions. So, when you're feeding data of let's say you're feeding engagement letters in for format stuff, or, you have to be careful about making sure what your AI is going to reveal about clients. For the most part, if it's internal, it's okay, but it's not always okay, because we have different Chinese walls to make things work inside the organization. So the permissioning and training of what the boundaries are for AI are about revealing stuff that's confidential it's a scary area when, these things sort of have a mind of their own. They also hallucinate. So that stuff gets kind of interesting.
Yeah. I mean, so I guess, where I'm going with that is would there be some information you would not want AI to be handling and training on, Chris, if you had sensitive client information, or maybe even your own personal sensitive information? Do you want, your employees knowing all of your personal details because you just happen to unleash your inbox on it, or unleash AI on your inbox, I should say?
Yeah, no doubt. I think that's something I'm concerned about, right? And how do company trade secrets or unique things about the company, and how that can get inadvertently disseminated. So those are risks. And nobody has been able to divorce the risk reward relationship. That's sort of an ever present kind of thing. And the pioneers take the arrow. So you either be willing to do it or not. We to try it, dip our toes in, understand, its limitations, test it in a safe group, and then you're gonna, there will be entries in the Encyclopedia of Dumb Shit as a result of trying this. There's guaranteed dumb shit that's going to happen, and we're prepared for it. It's okay.
Are there any other concerns you have about AI at this point besides privacy?
Yeah, it use case there are use case dependent concerns that are huge. What if there's an AI use case around HR and HR policy? What if one of your users discloses something to the AI, which it learns and subsequently discloses a health condition to somebody else about another? I mean, now you got all kinds of weird, did they tell somebody? Is an AI a somebody? Is it a public disclosure if they told an AI versus telling the company? Who the hell? There's no answer to this stuff in law. So at some point, law is going to have to come in and say, is the AI an agent of the company? When is the AI an agent? Isn't an agent a person rather than a robot? Like, what are we giving AI rights now?
Yeah.
So it becomes, there's going to be plenty for the courts to handle going forward around that stuff.
It's going to be interesting for sure. I think from my perspective, obviously privacy is probably the biggest concern for AI for any industry. What do you think about like the concerns about accuracy of AI though? Like obviously there was the big news article. It was like sometime last year where some lawyer cited a case that didn't exist because he was using ChatGPT.
I mean, it's so young, and anybody's relying on that stuff to write a brief to the court. That's crazy stuff. They do hallucinate. The models hallucinate. Yeah. So
and why he chose to do that when Lexis and Westlaw are just awesome. And it just, I think it was just lazy or dumb stuff.
But it goes to the point where I'm trying to go with this here is that I think putting blind trust in any technology is really scary. And I think that's where people tend to just automatically trust technology. And this is some new AI tool. OpenAI got hacked last year. Tons of data was breached. People are feeding stuff into ChatGPT. I don't think they really.
I don't know. You're optimistic about technology because you're in technology, but I run a knowledge firm that's national. I would tell you that getting professionals to even want to interact with technology, let alone trusting, is hard. So
I may have a little counterpoint on that. I actually wrote a book called Negotiating in the Technocracy. And when you're in like large, Fortune 100 firms, they do think that new technologies are going to be the messiah. There is this semi-religious fervor in a lot of these technologies that I've noticed, in doing this for actually 30 years now. So I think that a lot of people don't want it. There's early adopters, maybe like Chris and I, and there's people who will not do it. We had, this is another law firm, not Buckley, but we had some attorneys, some senior partners who didn't want anything but a paper, those pink paper memo messages that you have to handwrite out. They would not accept. They would print out their email and hand it to their secretary to deal with and reply to. So there are some people who are very on the other end of the early adoption spectrum for sure.
Yeah.
Chris, I know you got to go. So if you want to leave any parting comments.
This is it's fun stuff. We gotta try stuff. We gotta use it. It's gonna help. It's gonna help lawyers stay in their genius zone, waste less of their time finding shit, analyzing, comparing, have some of that be pre-digested for you. I think that's the first use cases that make sense for us and so many firms. And I'm delighted to chime in. And Martin's got it from here. It looks like he's in touch. So thank you all, and we'll see you soon.
Thanks, Chris. Appreciate you being on.
Thanks, Chris.
Take care.
Nice to meet you.
All right, Martin. So we'll turn this leave it to you to kind of give us your end cap on what do you think the cautions and the concerns with AI are from your perspective.
Yeah, I think you should start using it, adopting it, figuring out how to do prompts. You should not put any, as you stated, John, any private information. What am I talking about? Certainly personally identifiable information, certainly trade secrets. Engineers saying, oh, I have this really technical problem for a really arcane technology. I think I'll see what AI says. Well, if it's not containerized, then your competitors are going to have that same solution eventually because it makes it into the corpus. So on the privacy and security space, are you revealing different, and this is, your purview, different pieces of code that you're having AI, write a Python script to do this, that, and the other thing. Well, if it's written and if it's known, then it'll be known into the corpus, and that may be an issue, may not be an issue. Those are some of the things that I see. The good part is, let's say if I deal in, say, medical information, high security, there are tools out there that actually help, like personal injury attorneys, look through medical records and develop a narrative on how you want to present that to a court, let's say in a medical malpractice case or personal injury case or something like that. But those are discoverable attorney-client privilege containerized documents. It's nothing you should be putting absolutely on any public ChatGPT, Gemini, any type of public engine. There is a law-specific LLM that requires a configuration of a server that's beyond my knowledge and beyond what our IT can do right now. It's called Saul, as in Better Call Saul, kind of cute name, but it's very geared towards this, filling some of the gaps that your public LLMs have, geared towards the legal market.
Yeah, I think honestly, I feel like that talking about in 2 years, how do we get the detractions of AI eliminated? I think that's going to be a big one. Is how do we create standalone containers that it's kind of like having your own server almost.
Yeah.
That within each organization, maybe it's overkill. Maybe there's some ways to streamline that. I know there are. We're talking about Kubernetes and containers and things like that.
Yep.
How do we run our own, localized LLM on our own information that we can control? I think that's going to be one thing that's going to potentially help overcome those detractions. Also, just the general overall rule, and in thinking of if you are using a public AI system, like, is this something I would want leaked all over the internet, like my queries and the information I'm feeding to it? I know that Microsoft Copilot has some ways to kind of locally process that. I know Apple's new AI engine.
Yeah, you can. Yeah, that's neat. You can kind of drop it in SharePoint and just direct it to the training data, and it'll make training tokens based on what you do. So yeah, they're a little bit ahead of the curve, probably.
But then, the things I think about, Martin, as well, from a cybersecurity perspective is I'm trusting someone else to manage cybersecurity on a global level if it's on a public platform. Now I'm responsible for, if I'm going to shift it into my own private environment, I'm responsible for managing that data, because just because I have control over it, just because it's localized, doesn't mean that it's secure. It still means I'm responsible as a company.
Right.
And, from an IT and cybersecurity perspective, I'm responsible for my clients. For one, they got to coordinate with us and be like, hey, this is what we're going to be doing. But two, how do we make sure that we're being responsible with that information? Because it could still be hacked. Like, just because goes back to the whole, like, people think, well, my information's in the cloud, it's a lot easier to get hacked. Well, it couldn't be further from the truth. If anything that's connected to the internet, whether it's a server sitting in your closet here in your office, or if it's sitting in an Amazon data center, it could still get hacked either way. Yep. So I think that's the conversation people need to be thinking about as we propel into the future. How do we continue to secure these containers, whether they be in the public or private clouds?
Yeah. And yeah, that's so true. And how, I always imagine malefactors, bad actors, what would they do? Imagine if you knew the training data of an LLM, a public LLM, and you disrupted the training data. For example, a lot of, and then all the results you get were bad. What I like to do when I use public LLMs is basically I use a short sentence at the end, provide all citations, and give me links. Some of the links are bad. Some of the links, it may be like a scholarly work, doesn't support the notion that they did it. So it's not really hallucination. It's just it didn't find the thesis of that paper. There's some LLMs that use the Edgar database for SEC filings, which is very powerful, but it assumes that, if you upload a contract in your SEC filing, that it's a good contract. And it may be very deal specific. And if I wanted to undermine or reroute some of that training data somewhere else, it could really end up compromising the professional services you deliver. And which is why I think the people, if for law firms, if you want to start thinking about AI, you should have some type of committee. Cybersecurity has got to be the number one concern, privacy, security. And then you can talk about, of course, which that is all impacted on the ethical rules that the various bars are putting out. So know what the rules are and the limitations, and there's state regulation now on how you can use AI for different things. So there's a lot to be said about how we coalesce and use AI in the legal world.
Yeah, and you brought up a good point about the poisoning of AI.
Yeah.
And I don't think that's been talked about nearly enough. Again, potential cons is like some of these data sets could get poisoned over time and really mess with things. So I think that's going back to the point that was made earlier, is like there should still be humans involved in reviewing and managing AI.
Yep.
You can't just blindly trust it. So,
Exactly.
that I don't think we've seen very much poisoning happening yet. But again, it's going to be one of those things of like, if poisoning is happening, how will we even notice?
Right.
And again, that's going to have to be like, you're going to have to know your stuff.
Yeah.
And know like, oh, hey, look, this data looks odd.
Right. And it's a whole thing, because we want, on social media, we want to filter some bad data, but that really is difficult, because you can read I just read a report on a new particle was formed in nuclear physics or something, but then the next one will say, oh, that was wrong. So you have two different studies about something very fundamental, and you think you can objectively tell from these experiments what type of subatomic particle is, but there's a difference of opinion, and you have to gamble on one. And I think as long as there's what I call the information market mechanism, the truth will always come out to those who can observe and see objective reality. If you can't observe and see objective reality, the bad information is going to just proliferate.
Right. Any other thoughts about concerns that people should have, and cautions as they begin to roll this out?
No, there's one thing people can do, and especially websites of law firms. You really want to look at your terms of use and address AI's use of your website, because a lot of AI will go to articles that have been done 4 years ago that your firm published on their website. That's no longer good law. And so you want to have some type of disclaimer regarding AI scraping, or a copyright violation flag saying, hey, for this content on our website may not be scraped. So we're looking into different things like that to protect against potential liability of people relying on kind of like the passive world, the passive information that every law firm sends out into the marketplace.
Yeah, that brings up an interesting topic, and that is the fact that you have information on your website that is being scraped by AI.
Mhm.
And that's true for any industry, not just
Right.
legal firms. And that you want to make sure that you understand at least the fact that the quality of that content can influence AI models, whether somebody's doing research about your firm specifically, or even if it's generalized and it has
Yeah.
nothing to do with your firm could be helping AI or could be hurting it with your
Right.
content. And that's something to think about too. Like, Martin, what do you think? What do you think the implications are? Just to hear to pick your brain as we wrap this up. Like, what do you think the implications are? If effectively, I have, we have hundreds, Josie, if not thousands, of articles on our website, right? Um, about lots of
Right.
different topics about IT and cybersecurity. Essentially, the case could be made that I've helped contribute, and ByteGig's helped contribute to AI in some way, shape, or form without any
Mhm.
compensation.
Well, that's interesting because there are many class actions on that very topic. New York Times v. ChatGPT, of course, where the New York Times said, "Hey, LLMs are great with good data, and the New York Times has good data, and we make that better, and they're infringing on our copyright because in order to look at the data, you have to somehow copyright it, digitally transform it, or distribute it to get to the result." That's interesting because a lot of people, you can read, at least the front page of the New York Times and for free, but there are some sites that, like Book 2 and Book 3, that basically infringe and allow copywritten materials to be part of the internet. And it's whack-a-mole. Like Google, you can ask Google to not link to those if you're the copyright holder. I've done this personally with my books. So it's difficult as a publisher. The best you can do is provide notice in those terms of use and have some type of disclaimer that, hey, this is technology is ever changing. Don't rely on what we said any given time because we don't always update these articles, which is a disclaimer I'll give here. Nothing in this podcast should be relied on as legal advice.
Yeah.
That's kind of what you have to do in your website. If you want to have a social media presence, if you want to post on a blog, you want to have that disclaimer out there saying, hey, nobody should rely on this. Give us a call, including AI. You should not rely on this to provide good material. And you can say that. And that's that contractual right that we talked about. I mean, John, you've seen me speak a number of times on how important contracts are, and it's the best evidence of a meeting of the minds. And I really believe that terms of use are going to be pivotal in AI rollout, AI protection, and AI liability limitation.
Yeah. Yeah, I think that's definitely something that terms of use obviously definitely help in case something comes up, but like, are there going to be ways that companies should maybe limit AI from scraping their information to begin with?
There's I was at a CLE on the topic, and one of the speakers said the scraper, the AI, may be the malefactor, the bad party, because they're using copywritten information and they're training their LLM. We'll see how all that litigation shakes out in the next few years. The other thing is, what's the scrapee's liability? If you have information where an AI can distill personally identifiable information and publish it somehow, there may be scrapee liability, not just the AI scraper, if you will. And I think that's very significant because AI can piece together identities very quickly. You have, white page records, you have stuff. So if you have like a client testimonial, great. Make sure that can't be distilled to disclose the information of individuals, testimonials, things like this. If people can deconstruct who that person is and find out, in Oregon, for example, PII is described as two pieces of information linked together who can identify the individual. A lot of laws have that similar structure. So are there pieces of information where it could cause harm? If, a stalker finds out from your website some information of someone who gave you a testimonial or talked about their house in this town. So there's potentially scrapey liability as well.
Yeah. If you're revealing too much information that AI is able to put two and two together and do the math, figure that out. That makes sense. I think where, I guess what I'm thinking is, like, down the road, maybe there's going to be some sort of way to opt out certain types of websites or content sources and say, I do not wish this to be part of a AI training model, or maybe you have to just copyright everything you do.
Yeah. It's already copywritten. The minute you affix it in tangible form, it's copywritten. The issue is, do you register it? If you register it, then you get those statutory damages. And in the New York Times complaint, they're claiming the maximum amount of statutory damages for intentional infringement, which is $150,000 per act of intentional infringement. Thinking of how many queries you could have, those damages could add up. That's if you get those damages if you register within 90 days of publication, and you can bet the New York Times registers all their copyrights, pays their $35 or $55 to the Copyright Office and registers those. So they get those statutory
doing that for every single article, though.
You can do it if you're a periodical. There's a thing in the copyright code that lets you do it quarterly filings.
I see. So you could pay $35 or whatever it is every quarter, and it blanket covers everything.
With all, you have to, have PDFs of course, the copyright material or the sound recordings or other things. All that information for the viewers is on copyright.gov if you want to know how to copyright your stuff.
That's really helpful. I think there's a lot of content producers out there who are going to easily get their stuff ripped off by AI.
Yeah. And that's the only asset they have. And it's worth, $35, cheapest insurance if you can get up to $150,000 worth of statutory damages. Cheapest insurance going.
That brings me to my next question is, are there going to be AI tools that help to detect somebody infringing on your copyright?
There already are. We get... there's a lot of them are just basically, a pixel beacon in an image where it's a copywritten image, pixel beacon, and it reports back to the owner. And of course, they will send a demand letter, and we get a lot of these every week, demanding such and such dollars for infringement. This is why I think curating your website, the images, the text, do not cut and paste competitors' text. That's infringement. Don't steal other people's photos unless they're in the public domain or or have a license to those. That's already happening. They're already not only doing images, but AI probably can detect derivatives of images based on other images as the original work, because copyright has, a bundle of 6 rights, one of which is right to copy. Another one is the right to produce derivative works based on the original work. And then there's digital transmission, performance, and distribution rights as well. So licensing terms in your terms of use is the best contractual thing you have. And then, of course, you have to detect. The shield is make sure your content is original or you have the rights to it. The sword is those contractual terms. If you have knowledge of someone using your stuff, you probably want to talk to your attorney and send a demand letter out.
Yeah. Here's an even, I'm trying to stump you today. So I'm just having fun. I'm just having fun here. This is like totally off topic. So if you just tell me shut
It's
up.
all good.
But what if you used AI to generate your content that you publish on your website?
Who owns it?
Can you make any copyright claims on that AI generated content?
Already been litigated. There is a case, it's actually being appealed, whereby someone had an AI generated image, and this individual, he said, okay, I'm going to list the AI as the author. And the court said, no. Well, Copyright Office and the court said, you have to be a human being to own a copyright. So does the prompt engineer own the copyright? And I think, and this is being litigated as we speak, I would say it's a tool. It's like a painter using a paintbrush. That's a tool that I use to create an image. Well, by being a good prompt engineer, I can use prompt it to make an image that's unique with expressive content, a fixed intangible form. That's the three basic requirements of a copyright. If it's the expressive content, I can own the copyright, I think, as the prompt engineer. I think that's the way the cases will eventually end up. Again, this is my prediction, and I love predictions because there's no accountability. But I really think that prompt engineering will embellish the prompt engineer with the right to copyright that. The hard line is, well, if it based on something that looks similar, a copywritten work that looks similar, for example, it looks just like the cover of a National Geographic copywritten image, you run the risk of that being a derivative work without a license. So that's kind of the boundary. So if you are a good prompt engineer, look at that image and make sure it looks really new and fresh and innovative and creative and expressive.
Yeah, but it's hard. I think it's really hard to make the case that it's really new and innovative when somewhere back in time, somebody's image fed that learning model, right? But
Right.
at the same time, you could also make the argument, like, there's nothing new under the sun, nothing's original. I can go out and make some new logo tomorrow if I was a graphic designer, and probably someone somewhere has something similar that like had implanted in my brain the seed to create that. You know what I mean?
Right.
So
Yeah.
that opens up a whole different can of worms. I'm sure
And it is, it's a judgment call, and there are
Yeah.
different facts. Should it go to trial? There's different facts that would be presented in front of the jury about, were you exposed to the original work? If it was random, it's hard to say intentional infringement.
Yeah.
And you're right. Everything's a derivative work of everything else throughout history, right? There's no real, since we started making little triangles and cuneiforms, there's no progression of anything. Everything's built on something, and the only thing that nudges it forward is innovation and creativity. Article 1, Section 8, Clause 8 of the U.S. Constitution pushes America to innovate and create, because the founding fathers knew that this is the only thing we can do is, we have the original work, but if you can push it a little, just a little, that's innovation. That's how we get great works of art, interesting music, even though there's tons of, riffs that have been replicated. And then, of course, you have the whole sampling world. There's so much that is subjective. Is this original, or is it a derivative work? And those things are litigated daily in the courts. But the best you can do is be creative and take the risk. And if you make a mistake, it's probably baked into the cake, I think. And if it's intentional, well, shame on you.
Yeah, and again, this may be a little off topic for law firms, but I think that law firms that are using AI are also going to be, they're also going to want to be, kind of ready for these conversations. So I think the more we can educate and inform people about, especially you're talking about copyright, and how AI is going to play into the future of copyright laws in courts, and I think that's really important too.
Yeah. And how does the law advance? The law is advanced by innovative and creative applications of the law to the facts. But that's all public information. If it's a reported case, it's reported in a reporter, an electronic database now. We used to have old-fashioned bound documents when I went to law school, but it all gets uploaded to Westlaw and Lexis, and that becomes part of the corpus, and anyone can use the law. You can't really have an intellectual property right on the published law, but innovation, creativity, and pushing the boundaries of argumentation, logic, and applying the laws to the facts is what advances the law and advances AI as well. So I think maybe AI may be an innovative force, and in which case the laws may change.
Yeah, for sure. Well, I know we're wrapping things up today, so I'm going to skip ahead on a few things. But, for our listeners today, if you're a law firm and you're interested in getting involved in AI, interested in making sure it's secure and private, things like that, we strongly recommend you reach out to us here at Bite a Gig, and we can help you, guide you through that journey. And I also want to strongly recommend anybody who's here with us here today still has hung on for this conversation for 58 minutes. And I hope it's been a good use of everybody's time. I certainly have learned a lot from this. So, but we strongly recommend subscribe to our Bite a Gig podcast. Martin's been a guest on it before, and we had a great episode with him. And we have many other thought leaders in the technology and cybersecurity space. And get to hear Josie, you get to hear myself, you get to hear our guests. So recommend that you subscribe to that on Spotify, and it's now on Apple Podcasts as well. And then every Wednesday we go live on LinkedIn here. This is our weekly LinkedIn Live today, but next week at 10:30 a.m. Pacific time, we'll have a cybersecurity briefing and talk about the news. And Martin, you and I talked about Columbus briefly on your podcast, in fact.
Yeah.
And this has been just an ongoing unraveling. And I don't know if you've looked into anything about that situation after you and I spoke about it. But
yeah, I have not had the update. What is the update?
Yeah, I mean, I guess they were able to kind of come to some sort of agreement to stop the guy who was blowing the whistle on him.
Yeah.
But I think it's still, that piece of it's still an ongoing battle. And I don't think there's any real conclusion to that story. And there probably won't be on multiple fronts. So anyways, I know Josie had to drop off. Chris had to drop off, and I know we're hitting up the top of the hour here. So thank you again, Martin, for showing up.
Thanks, John, and thanks, Josie.
This is like our third time we've done a production together, and I really enjoy it, Martin.
Yeah, it's totally enjoyable for me, John. I really am honored that we came together and we have so much to chat about.
Yeah. All right. Well, we got more to pick your brain about later, so it's probably won't be the last time.
Sounds great. All right,
Thank you so much, sir.
You take care.
Thanks, everybody.